Thank you, Mr. President. This is a Judiciary Committee substitute for the Workforce Committee substitute for introduced Senate Bill 222. It relates to eligibility for unemployment benefits. The nuts and bolts of the bill are that it amends a single section of the West Virginia Code. It is Chapter 21A, Article 6, Section 3. And that section delineates the circumstances under which people are disqualified for receiving unemployment benefits. In short, what this bill does is that it clarifies that workers who voluntarily go out on strike are not eligible for the period while they're on the strike to receive unemployment compensation benefits. The bill makes clear that workers who are locked out, as opposed to going on strike voluntarily, who are locked out, are eligible to receive unemployment compensation benefits. I'd be happy to answer questions, Mr. President. I urge passage of the bill and would reserve the right, if I may, to close debate.
Question before the Senate is, shall the bill pass? Is there further discussion? The gentleman from Marion.
President, will the senator from Oregon yield?
Does the gentleman yield? The gentleman does yield. The gentleman may proceed.
Thank you, Mr. Chairman. I'm having a little bit of trouble understanding, first of all, the intent of this bill, whether it's, to identify if a lockout, in fact, is taking place and who would make that determination. And also, in speaking with the chair of the Workforce Committee, I guess his major concern was that, taxpayers are paying for strike benefits, and his feeling is that maybe the union should pay out. So what is the original intent of the bill?
The intent of the bill, in my opinion, and it's certainly in, I think, our committee's judgment, as it came through the Judiciary Committee, is to make it clear that people who voluntarily strike are not going to receive unemployment benefits while they're on strike. And we distinguish within the bill between a strike and a lockout. The difference is delineated in the bill. If people are locked out by their employer, that's a different situation. But what the bill says very clearly is that if workers go on strike while they're on a strike, they're not going to be able to receive unemployment compensation benefits. So, go ahead.
From my understanding, the code is clear now, and it's been that way for the past 25 years. What has changed that we need to, take this bill and modify it to the fact that it would do something differently than the existing code?
And it may be true that the original intention of the language that's currently in law was to make that differentiation between strikers and people who are locked out. But what we found out during our consideration of this bill, and a similar one last year, is that's not the case. The way the workforce apparently determines whether something is a strike or a lockout historically has been whether it has to do with who replaces the workers who are out of work. And so to us, that didn't make any sense. To the gentleman from Marion, the distinguished minority leader, I'll let you know that we have received a fiscal note on this bill. And the fiscal note says that if we pass this into law, we're going to save $176,000 and some dollars in fiscal year 2018, which I interpret to mean that the state believes, workforce believes, that we have been paying workers unemployment benefits while they're on strike.
So in determining the lockout, has there been a problem in the last 25 years where there's been an excessive amount of lockouts?
Apparently there is some difficulty in differentiating between the two. Now, what this bill says, it's in subsection C on page 4. It says an individual is determined to leave or lose his or employment by reason of a lockout where the individual employee has established that, 1, he's presented himself or herself physically for work and identified that he or she was reporting and prepared for work on the first day of a lockout or on the first day that he or she is able to present himself or herself. And the committee's thinking on that was, well, if somebody's sick on the day one, you know, that there's nothing magic about day one. It could be the second or third or fourth day. And two, the employer denied the individual the opportunity to perform work. So the burden is on the applicant for benefits to show that he or she is locked out, but this says exactly what they have to show. They have to show that they were prepared to go to work and they were denied the opportunity to go to work. And if they can show that, then the finding will be that they were locked out of work.
So who makes that determination now, whether it's a lockout or a strike?
Ultimately, it'll be workforce, because the workforce administers the unemployment compensation program. There's a hearing process and an evidence-taking process in that. So the way it works is, you know, if I lose my job and want to apply for unemployment benefits, I go to an unemployment office and fill out an application.
So as it stands right now, workforce makes that determination. Who presents the evidence to workforce, or is that a commissioner that hears the evidence? Does the employer do that, or do employees have to do that?
I think it's an administrative, adjudicative process, so both sides have opportunity to present evidence. I think, you know,
where does the burden of proof fall on? Who has to prove
under this
present
bill?
Evidence?
Under this bill, the burden of proof falls upon the applicant for benefits. So if I am a worker who is applying for unemployment benefits, the burden is on me to prove that I was locked out as opposed to on strike. Now, we talked about that at length in the committee, and
and I'm sorry I wasn't on the committee.
That's
so
all right.
That's why I'm answering
And
the
it's a
question.
great question. It's a great question because the allocation of the burden of proof is important in any sort of adjudicative process. What we learned is that is the same as current law. The current law has been in effect for nearly 50 years. The burden on that question falls, whether this bill passes or not, falls upon someone who's applying for the benefits.
So would this piece of legislation increase the length of the hearings and the process that you go through to prove that? I mean, would it just tie folks up longer to receive an opinion, extend the time period to do that?
I wouldn't think so. Of course, there's no way to know that for sure, and I'm sure that in some circumstances those questions are more complicated and harder to resolve from a factual and an evidentiary standpoint than in other circumstances. But in general, I don't think so. I don't think there's anything in this bill that's going to make it a more lengthy or difficult administrative process to find the answer to that factual question, which is, were you on strike or were you locked out by your employer?
So in looking back, who would you think, if this legislation passed, that this bill would favor? The employer or the person trying to receive the benefits?
I think it will favor, I think it's a fair balancing of the interests of both. And I believe, I could be wrong, but I believe the vast majority of West Virginians agree with and will agree with the concept that's embodied in this bill, which is this: if you decide voluntarily to go out on a strike, that's not the same as losing your job, being riffed, or even being locked out. And you shouldn't be able to receive unemployment compensation benefits when the decision not to work was the decision that I, as a worker, made.
Well, I agree with you there, and from what I understand, that's existing code. If I choose to go on strike, then I don't receive the benefits. But if my employer locks me out, locks the business down so that I can't go to work, then I should receive those benefits. And as I understood it, that's existing law. I'm having trouble understanding, if this legislation passes, is it going to make it easier for people that have been locked out to receive those benefits? Is the process going to be expedited? I mean, I'm having trouble understanding that.
Great questions. I would say I don't think that this expedites the process. You know, it'd be nice to be able to try to make processes move along faster. I have to concede, I don't think this does that. I don't think it slows it down significantly either. I think the process is still the process, but what this bill does is make clear what is the distinction between going on strike and being locked out. It sounds like, to me, you're in accord with me. You believe, as I do, that striking workers should not be able to get unemployment benefits, but those who are locked out, you know, who didn't choose not to be working that day, should be eligible.
Sure,
and that's what we're trying to do in this bill, and what we found out is that we need this bill because that is not clearly delineated in our law now.
Well, I wasn't aware that there's been a perpetual problem over the past 30 years as the legislation exists. So what prompted the legislation in the first place? I mean, have there been a lot of problems that we don't know about?
I think there have been some problems, and I think that sort of underlies the fiscal note that we've been given that says that if we stop paying benefits to workers who voluntarily go on strike, we're going to save $177,000 in this fiscal year. Now, I'll concede that fiscal notes, this one, like all others, must be based in part upon assumptions, because no one knows where strikes or lockouts for sure will occur over the course of the next fiscal year. But I believe Workforce based this projection on the 2016, 15, 14 data they have.
Thank you, sir.
Thank you.
Further questions? The gentleman from Upshur, or excuse me, the gentleman from Harrison.
Thank you, Mr. President. That'd be quite a move for me, and I appreciate that. I like Harrison County. Senator from Oregon, continue to yield. Thank
Gentleman
you.
yields.
Senator, I'm of course on the committee, and I'm still at a loss over this bill. And just to kind of set the stage, we considered this very issue last year. We made some changes, which, you know, made it a little clearer, and then it died in the House. But this bill, I think you'll agree with me, certainly changes the standards and changes the bar that must be reached by employees to prove that they're being locked out.
The case we found, I won't necessarily concede that point, because the case that we found that was 50 years old has said that the burden of proof on this question is on the applicant for benefits.
No doubt about that. No doubt about that. First of all, I mean, the evidence was in committee that there had only been one decision by the commissioner in the last 10 years that had been reversed from a lockout to a strike, because we have to realize that always, for the last, you know, decades that this law has been around, you can't get paid unemployment if you go on strike, but you can get paid unemployment on a lockout, right?
I agree that that's what the law should be, and that is exactly what this bill endeavors to make clear.
Well, that's what the law always has been. We're just kind of changing around some of the standards of proof with this bill to make it a little bit harder to prove that you're in a lockout. And I'm going to go over that, but certainly that's always been the law. You can't get unemployment if you're on strike. You can get unemployment if you're on lockout. And I tell you why it's important to me, because in my county, we had 60 people that worked for a specialty glass company down there. They'd been working under a contract that had expired months and months before, but they continued to work under those terms. The company, which was making a good profit, very good profit, wanted to cut their benefits drastically. They continued to work, and then one day they came to work and the gates were locked. And now, we know what a lockout's for, right? And I'm going to tell you, because I know you know, but a lockout is used to coerce employees into taking less in wages and benefits than they otherwise would, because they get starved. Because when you're locked out, you're not getting a paycheck. When you're locked out, if you can't get unemployment, your family's going to starve. It kind of makes you a little desperate to take whatever deal they're giving you. I mean, that is a lockout, correct?
Well, to my good friend from Harrison County, if there's a question in there, I would say that the answer to the question is the hypothetical that the distinguished senator from Harrison County just described would, in my opinion, be a lockout.
Correct. Correct.
And that those people would not be, under this bill, disqualified from unemployment benefits.
And I wanted to ask the sponsors some questions, but I'm going to stick with you, Senator, because I know you're knowledgeable about this stuff.
But I'll be happy to hand the microphone to the sponsor.
We'll get to him here in a second. But one of the things this bill does is it takes away a lot of the discretion of the commissioner. For example, the commissioner was always able to consider under the statute that's been around for decades that if an employer cuts the wages and benefits of its employees, for example, if they're making $25 an hour and the employer says, look, you can keep working, but it's $8 an hour, that was a constructive lockout under the old statute. We're taking that discretion away from the commissioner, therefore making it harder to prove that those employees are locked out. Would you agree? Well, let's take it one at a time. You may not agree with the last part, but we are taking away that discretion from the commissioner.
One of the purposes of the bill is to eliminate some of the discretionary judgment that a commissioner has and to try to define what is a strike, what is a lockout, and not have it be subject to someone's arbitrariness or discretion. That's our job as legislators to say, here's what a strike is, here's what a lockout is. A, you can't have benefits, B, you do. So the answer to the gentleman's question is yes, it does. It removes some discretion.
This is a facts and circumstances determination, just like when we go to trial, both sides present evidence and judge makes a decision, but we're taking away that particular issue where an employer might cut the wages and benefits of the employees to such a drastically low level that it's a constructive lockout. We're taking that discretion away. And I appreciate that answer. And another one we're taking away is if employees try to collective bargain with an employer and the employer refuses, that's no longer considered a lockout in a way that would champion collective bargaining. It's now the opposite. They would be considered on strike even if the employer refused to deal with them in collective bargaining. Similar to the manner we did with regard to the cutting of benefits.
Well, now, I'm not sure I'm going to agree with the gentleman on that, because our bill says, this bill says that if the employee establishes that he was presented himself or herself, was ready and able to work, and was denied the opportunity to work, then this says he or she has been locked out.
And I agree, and you're kind of jumping to the conclusion. I appreciate that. But the statute we passed says that if an employer denies employees the right to collective bargaining, under current law, that would be a lockout. But under our new bill, that would then be a strike and deny them any unemployment benefits. Correct?
Yeah, the answer to your question intermixes federal law and state law. So there are aspects of that that are controlled by federal law under the National Labor Relations Act that, of course, this legislature has no authority or power to amend or preempt. Well, even though it attempts to do so, maybe. But no.
Okay.
Never would we.
Well, let me talk about the higher bar we've created. And again, this is between lawyers, and I know this bores everybody, but the employee, the burden's always been on the employee to show that they're locked out, but now we've created specific standards to prove that lockout. One is which that he or she has to prove that she reported for work, and that he or she asked to go to work, and that he or she was refused work, and that he or she was told that they could not have access to the workplace. And I understand those, but in the realm of bringing in evidence before the commissioner, how can we prove the negative that I appeared at work and somebody told me to go home without subpoenaing everybody who would be at the plant to be able to testify to that?
Well, your own testimony would be competent evidence and admissible in an unemployment benefits application case, an adjudication. The applicant is a competent witness. You would say under oath, I endeavored to go to work. I attempted to go to work, and when I got there, the gate was locked. They wouldn't let me in. That's competent, admissible evidence, and if it's unrebutted by other evidence, I would suggest that it's sufficient to carry the day on the question.
Absolutely. If it's unrebutted, then that's the only evidence there is. But if it is rebutted, it would really require the subpoenaing of many of the people in the plant that were there on that day that would be able to testify those facts for every one of these employees.
It could. It could, but I would submit that that's the case now. That's not changing anything from current law. In a case where the question is, were the workers on strike or were they locked out? All of that is relevant, admissible evidence now, and it would continue to be so under the passage of this bill.
Except what we've done is we have created a permanent standard where before it was within the commissioner's discretion to look at the evidence that might be presented just by the employee themselves. Now we've said they have to prove these specific steps were taken, which of course requires more evidence, whether it's they have to subpoena one person or they have to subpoena 50. They have to prove that point.
I agree and I disagree. I agree with the gentleman's point that, yes, this bill creates a standard. And I would suggest to my good friend from Harrison County, that's what a legislature's job is, to establish the standard. What has to be proved to sustain a cause of action, to receive a claim for benefits. That's our job. We shouldn't leave that to the discretion of some bureaucrat without guidance in the law. Now, whether it makes it more difficult, I could argue make it easier. The applicants for benefits, employers, their attorneys are going to be able to look now at a statute, decide and see this is what has to be proven or this is what we have to negate in our proof, and we make the roadmap easier for everybody.
Well, I mean, the roadmap can create a lot of mountains, a lot of hurdles to get over. This is certainly one of those, but with regard to the last hurdle, or one of the other hurdles that we created, which was to prove that the employees who replaced the locked out employees were either permanent or temporary, we had testimony there from the labor lawyers, from several labor lawyers, that said that would necessarily require the subpoena of all of the replacement employees in order to carry that burden. That's going to greatly increase the amount of time and litigation that's necessary to prove that you've been locked out. I mean, that's inevitable, isn't it?
I don't think so. I think, it could mean additional evidence for the members. The language that the gentleman is referring to is in the subsection D of the bill. But sometimes cases take great amounts of evidence to prove, sometimes they don't. The bottom line is, it is the responsibility of this legislature to set the legal standard, and this bill does that. To delineate what has to be shown or proven, this bill does that. To delineate who bears the burden of proof, this bill does that. If the counter argument is, well, let's not set those standards or require or establish who needs to bear the burden of proof, and stay with our current alternative, which is just leave it to the absolute sole discretion of an administrative judge for workforce to decide, okay, we're just going to pay a bunch of people benefits, even though they're on strike, is not a good system.
Well, and I understand that is our responsibility. Our responsibility is to create laws to fix things. I mean, we had no evidence that anything needed fixed here, and like all judges, get to judge and make decisions based on the facts and circumstances. The final hurdle that we've placed in front of workers is that under the old law, or under the law we're replacing with this statute, is that if work did not resume after 4 weeks after the end of the lockout, that the burden was on the employer to show why work hadn't resumed. We've now pushed that to the employee. Again, isn't that unnecessary in that the person who would know why work did not commence or not at the end of the 4 weeks would be the person who's operating the plant?
I think this makes things clearer and easier and fairer in the way this is done now. What the gentleman said is correct. This does strike language that provided for that. As we discussed earlier, the old law said the burden is initially on the applicant, but the statute says after 4 weeks the burden shifts. That makes absolutely no sense to me. It never could, that you'd have, you know, what's magic about 4 weeks and then in the middle of that you're going to say a burden of proof shifts to someone else. To me, what this bill does, or will do if it passes, is logical. It keeps the burden for the evidence and proof on the same person throughout the proceedings.
And I guess, Senator, this might really be a question for the sponsor, but, you know, given the evidence that we took in committee, and I was there with you the whole time, and I guess I'm going to be asking this question a lot this session, but given the evidence that we took that this statute has operated effectively for decades, and that it's protected workers who are being coerced into accepting less wages and benefits by being locked out, and that only one case was there a reversal of the commissioner's decision, I think they said in the last 10 years. Why are we doing these things to make it harder? Whether it clarifies or not, how does this benefit West Virginia workers? And why are we passing this bill when there's no need? Understanding our responsibility.
Well, it's a great question, and I'll tell you what I think. I'll give you my opinion. You know, West Virginia has higher unemployment right now than the national average. In fact, we have the lowest labor force participation rate in the country, and we're paying for it. Right now, you know, every year, our unemployment compensation fund has to borrow $50 million from the West Virginia Rainy Day Fund to pay unemployment benefits to West Virginians who are laid off, RIF'd, as a result of the downward spiral we've seen in our economy. So, to me, it's a question of, are we going to make sure that the premiums, the money that's paid into that unemployment compensation fund by taxpayers, employers, is preserved for the people whom we all agree truly deserve it because they've been laid off or RIF'd? Or are we going to have an administrative judge paying out benefits to people who voluntarily walk off their job and go out and strike and set up a picket line? And I say no. We don't have the luxury to spend those unemployment benefits to subsidize that sort of labor activity.
And I am with you 100%. You voluntarily walk off your job in a strike, you don't get unemployment benefits. That's always been the
bill
law.
says.
That's always been the law, but now what we've done is we've made it harder for workers that are forced out of work to get unemployment benefits. And let me add this last point for you before I move on to the sponsor, is that we did not receive any evidence that locked out employees were in any way affecting the fund. I asked that question. Nobody said that locked out employees were a drain on the unemployment fund. What's a drain on the unemployment fund is our people aren't working. And in 2014, it was the opposite.
You mean striking. You mean striking, not locked out, right?
No, I'm talking, there was no evidence that there had been impermissible lockouts or lockouts that were incorrectly decided as lockouts that were affecting the fund in any way.
Well,
there was no evidence that was introduced to my recollection. You can correct me if I'm wrong.
Well,
as a matter of fact, there was only one lockout that in the last decade had been reversed and said, Commissioner, you made a wrong decision, it was really a strike.
You know what we've had and we've seen absolutely inconsistent and irreconcilable decisions that have come out of workforce or labor on that question. One of them, you know, from 2003, where the review board awarded benefits to striking Kroger workers, but in 2012, the review board ruled that striking workers at the Constellium aluminum plant could receive unemployment compensation because there was not a stoppage of work. So we've been all over the board on it. I disagree with the gentleman's point that there haven't been problems. There have been problems. That's why we have this bill. This bill seeks to address them fairly fundamentally in the way that I think we're in agreement upon. If you're on strike, you don't get unemployment benefits.
And again, I couldn't agree more with that last statement, but certainly this bill has taken a system that has worked well, with even the couple exceptions you mentioned, and has made the standard almost impossible for the individual worker to try to overcome. But thank you, Senator, and I appreciate your time and all your questions and answers.
Thank you.
The question before the Senate is, shall the bill pass? Further discussion? Further discussion? If not, would the Senator from Morgan like to close? If not, the question before the Senate is, shall the bill pass? All those in favor will vote yes. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there being 22 yeas, 11 nays, 1 absent and not voting, more than a majority of those present and having voted in the affirmative, I declare the bill passed.